Oh, hi, everybody. My name's Joe Murphy, and welcome to the video. We're here today to talk about some topics in patent law, particularly from a prosecution perspective. Reza?
Hi, my name is Reza Mollaaghababa. I'm a partner like Joe in the Potomac Law Group. And as Joe mentioned, this is the first of hopefully a recurring series of videos on IP topics.
Yeah, sounds good. And then, of course, the since we're lawyers, the disclaimer: the information provided here does not constitute legal advice. Instead, it is for general informational purposes only. Viewers should contact their attorney to obtain advice with respect to any particular legal matter. The opinions expressed herein do not reflect the views of Potomac Law Group or its clients. So today we're going to discuss a couple decisions on obviousness that have recently come down from the Court of Appeals for the Federal Circuit, which is, of course, the appeals court that handles patent law issues. And then, as we mentioned, I think it's going to be really from a patent prosecutor's perspective. That is, folks who are trying to get patents to issue. So let's look at obviousness first. Okay, I'm gonna screen share, and so we can bring up the slides. There we go. Yeah. And okay, so this is Title 35 of the United States Code, Section 103, has to do with obviousness. So a patent for a claimed invention may not be obtained, mentions 102, if the differences between the claimed invention and the prior art are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having ordinary skill in the art to which the claimed invention pertains, and patentability shall not be negated by the manner in which the invention was made. As patent prosecution specialists, I would say that really the decision we usually deal with in terms of obviousness is, of course, the Graham v. John Deere decision, which set forth that obviousness is a question of law based on underlying factual inquiries, which include determining the scope and content of the prior art, ascertaining the difference between the claimed invention and the prior art, and resolving the level of ordinary skill in the pertinent art. And in the prosecution context, and also in litigation as well, there are some other factual matters which come up, and that's objective evidence relevant to the issue of obviousness, sometimes called secondary consideration. These include evidence of a commercial success, long felt but unsolved needs, failure of others, and unexpected results. So I'm going to jump right into the first case we're going to look at today, which is a generic pharmaceutical case. So this is Salix Pharmaceuticals Limited versus Norwich Pharmaceuticals Incorporated. This decision came down from the Court of Appeals for the Federal Circuit a few months ago, back in April. And the subject matter is rifaximin, which is a widely used antibiotic. The brand name is Xifaxan. And the FDA had approved this 550 milligram tablet doses for treatment of hepatic encephalopathy back in 2010, and for irritable bowel syndrome with diarrhea, that's so-called IBSD, in 2015. Norwich, the generic manufacturer here, sought to market the generic version of rifaximin, and in 2019 filed their ANDA for the 550 milligram tablets with the same indications of Xifaxan. There were a number of other issues that arose during the litigation, but we're going to focus on two groups of patents, essentially, a 569 and 667 patents directed to treating IBSD with 550 milligram rifaximin 3 times a day. So that's a total of 1,650 milligrams per day dosage, which is important. There's a limitation about 14 days, and the other patents are the 199 and 206 patents are directed to rifaximin form beta. That's a polymorphic form, crystalline form. So let's look at the claim of the IBSD patent. So this is just a representative claim, so or couple. So claims 1 and 2 of the 569 patent directed to a method of providing acute treatment for IBSD, essentially comprising administering 1,650 milligrams per day of rifaximin for 14 days to the patient And then it's got this other limitation where in removing the subject from treatment after 14 days results in a durability response, comprising about 12 weeks of adequate relief of symptoms. Second claim is method of claim 1, wherein the 1,650 milligrams daily dose is administered at 550 milligrams 3 times per day. So let's look at the litigation at the district court level. So Norwich, again, that's the generic challenger, challenged the validity of these IBSD claims by asserting the claims were obvious over essentially 2 pieces of prior art: a clinical trial protocol that had been published on clinicaltrials.gov in 2005, describing a phase 2 study evaluating twice daily doses of 550 milligrams, that's a total of 1,100 mg per day, and 1,100 milligram doses at twice a day, that's 2,200 milligrams per day for the 14 days, and also 28 days for the treatment of IBSD. There's a secondary reference, Pimentel, published in 2006, which taught administering 400 milligrams 3 times a day, that's 1,200 milligrams per day for the treatment of IBS. This reference also had a line that said the optimal dosage of rifaximin may, in fact, be higher than that used in our study. Interestingly, the court relied on, there were some references presented to the court regarding this condition called SIBO, which is small intestinal bacterial overgrowth. And the argument was that this is highly prevalent in patients with IBS, such that SIBO decontamination is associated with significant improvement of IBS symptoms. Several references. Quacco taught a efficacy of 1,200 milligrams for rifaximin per day for 14 days for the treatment of SIBO. Loretano taught a treatment of SIBO as doses will increase from 600 milligrams per day to 1,200 milligrams per day. And Scarpolini reference reported a 1,600 milligrams per day dose showed a significantly higher efficacy compared with the 1,200 milligrams per day for the treatment of SIBO. The name brand, Salix, argued that even if the asserted combination of references effectively disclosed the claimed 650 milligrams per day dosage, there remains insufficient evidence to support a finding of a reasonable expectation of success in using that particular dosage amount. According to Salix, the highest prior dosage amount that could have been supported with a reasonable expectation of success was a 1,200 milligrams per day dose evaluated in the Pimentel reference. So the district court found that these 2 references, the clinicaltrials.gov and the Pimentel reference, disclose each and every element of the challenged IBSD claims, and further found a skilled artisan would have been motivated to combine the references to arrive at what is claimed with a reasonable expectation of success, and therefore concluded that the IBSD claims were invalid as obvious. On appeal, the Court of Appeals for the Federal Circuit found that Pimentel does not merely provide the daily rifaximin dose of 1,200 mg worth likely to be successful in treatment of IBS. It also taught, and this is a line that had been relied on by Norwich, recent data suggests that the optimal dosage of rifaximin may, in fact, be higher than that used in our study, close quote. The Court of Appeals found no clear error in the conclusion that there would have been a reasonable expectation of success in administering the claimed 1,650 milligrams per day to IBSD patients, and also set forth certainty and absolute predictability are not required to establish a reasonable expectation of success. Let's take a look at the polymorphic patent claims. So we'll just look at this one. Claim 4 of the 199 patent recites rifaximin in polymorphic form beta, wherein the rifaximin has X-ray powder diffraction pattern peaks at about 5.49 and 20.9 degrees 2 theta, and wherein the rifaximin has a water content of greater than 5%. If we look at the proceedings below at the district court, Norwich had cited a reference called Canada, which discloses rifaximin exists in crystalline form and also had outstanding antibacterial properties. This Canada reference did not disclose the crystal structure in detail, but it did give several ways, protocols for preparing rifaximin, including solvents used for crystallization. And the court found that a skilled artisan would have had good reason to characterize crystalline rifaximin following the Canada protocols, and that such characterization was routine and could have performed, quote, in one day, close quote, and that doing so would have led the skilled artisan to have detected the rifaximin form beta, and therefore concluded that the challenged polymorph claims would have been obvious over the asserted prior art view of the common knowledge of the skilled artisan. At the Court of Appeals level, found that the scope and content of the prior art included preparation of crystalline rifaximin, which expert testimony supports would have yielded the beta form of rifaximin, and that Salix has done no more than combine known elements of the prior art to verify readily accessible information concerning a compound already in the hands of those ordinary skilled in the art, and such routine efforts do not justify removing this polymorph from the public domain. It's interesting that none of the references cited necessarily taught the 1650 milligram per day dosage, and also none of the references disclose the polymorphic beta form. So I'll point to the dissent in the Court of Appeals decision, which set forth that the reasonable expectation of success analysis must be tied to the scope of the claimed invention, i.e. here the claimed 1650 milligram per day dosage for treating IBSD. The dissent further characterized the clinicaltrials.gov reference as stating that the 2200 milligram per day dosage, quote, did not achieve more responders compared to the placebo for adequate relief, and stated that the court's reliance on this clinicaltrials.gov to establish a reasonable expectation of success was erroneous. And there was a lack of discussion of any actual dosage that may be optimal, and that the use of the word may in the Pimentel reference and the fact that the clinicaltrials.gov disclosed a specific dosage regimen of 2200 mg per day rather than the 1650 milligrams per day all call into question the majority's finding. Salix had argued that the Scarpellini-Laurentana references were directed treatment of SIBO, that small intestinal bacterial overgrowth, not to the treatment of IBS or even IBSD, and therefore cannot establish a reasonable expectation of success. Although the majority may have been right that Laurentana and Scarpellini's disclosures on treating SIBO also support a reasonable expectation of success for treating the IBSD, the district court never made this finding. So that's one aspect of obviousness. Now I'm going to turn it over to Reza, who can discuss another case.
Thanks so much, Joe. The case I'm going to discuss is in a very different field. It's not in the pharmaceutical area, rather it's in sort of electromechanical, optical area. It's Virtek Vision International versus Assembly Guidance Systems. Next slide, Joe, thanks. So Virtek is the owner of this patent that basically has to do with projecting a laser pattern on a work surface in a very precise manner. And apparently this has applications in a variety of industrial areas. Next slide, please. So this is figure 1 of the patent, shows the system, and basically the idea here is that they put certain reflective elements on the work surface. They use 2 cameras that here are noted by 44 to obtain an image which allows them then to obtain 3D coordinates of these reflective elements, and that then helps a laser to illuminate those reflective elements, and they look at the retroreflection of the light from the laser to obtain a more precise position of those reflective elements. That then allows the projection system to project in a very precise way the laser pattern onto the work surface. Virtek sued Assembly Guidance. Next slide, please. We can skip this. This is basically shows schematics of this 2-step process of first finding the coordinates of the reflective elements and then using the laser to obtain more precise positions. Next one, please. The claim at issue here is this claim 1 and some of the dependent claims. And as you can see, the bolded areas of the claim show the idea of this sort of two-step process where the reflective elements are initially determined in the 3D coordinate system, and then their positions are more precisely identified using the laser source. Next one, please, Joe. So, as I said, Virtek sued assembly guidance, and assembly guidance filed an inter-parties review, IPR, to invalidate the patents of the Virtek patent. And this is sort of a summary. This slide shows a summary of the grounds in the IPR. I'm going to concentrate on the first ground, that is the combination of Kittler and Briggs, that the petitioner, namely assembly guidance, had cited against claim 1 and some of the dependent claims. So Kittler, next slide, please, has to do with, again, a projection system that uses a retroreflector and reflection from it to essentially calibrate the position of the projection system in an environment. And here the retroreflector is 16, the system is 14, and it uses a two-step process. Initially, it finds an approximate position of the reflective element 16, and then uses that approximate position to be able to send a laser beam to the retroreflector 16, and using the back reflection to obtain a more precise position of the reflector. But it doesn't, when it finds the approximate position of the retroreflector, it's not the 3D coordinates, it's simply the angular position. And the next one, the next reference that was cited by the petitioner, Briggs, is a laser tracking system. It operates in two modes. In one mode, there is one camera that can determine the angular position of, again, a reflective element on an object that is being tracked. And then in another mode, it uses two cameras to obtain the 3D coordinates of the retroreflector on the object. And the position of petitioner here was that, well, if you take the 3D embodiment, 3D coordinate embodiment in Briggs and put it in Kittler, you obtain the claimed invention. And in fact, it seems like that's the case, because Kittler clearly shows the two-step process. You simply change the first step that relies on the angular position with the system that is disclosed in Briggs that determines the 3D coordinate system, and you would arrive at the claimed invention. That was the position that the petitioner had taken. The board, the IPR board, agreed and basically reached the conclusion that the claim was obvious over the combination of these two references. But interestingly enough, CAFC reversed the board's decision. And the rationale for CAFC holding was that it is true that these systems were known, but the petitioner had not provided any reason that one of ordinary skill in the art would go to the Briggs system and pick the 3D coordinate system in Briggs and use that in Kittler. And in fact, the CAFC opinion refers to an earlier case, Belden v. Virtek, and there's a statement here from that case that was guiding, I guess, CAFC's decision. And that statement is here on the slide at the bottom. It says, obviousness concerns whether a skilled artisan not only could have made, but would have been motivated to make the combination or modifications of the prior art to arrive at the claimed invention. And here, basically, the point of the CAFC decision was that the mere fact that these elements were known was not enough to show obviousness. You need to indicate why somebody would have combined them, and they reached the conclusion that that reasoning was absent from the IPR petition. So that is really a summary of this case, and Joe now can talk about some of the ramifications in terms of the way we prosecute cases.
Yeah, I think I think there's a couple of takeaways here. And it's interesting, Reza, that these cases are kind of flipped in a sense, right? Because pharmaceutical cases are often considered to be an unpredictable art. And then the case you looked at is more predictable, but it kind of flipped, right? In the
Right.
pharmaceutical case, they said there was a reasonable expectation of success and there was motivation to combine, whereas in your case, they found there was no motivation to combine the references. So I think, you know, the takeaway that I get from these cases is that, you know, as patent prosecutors, we often see these obviousness rejections, obviously coming from the examiners. But, you know, one thing to look at in office action, obviously, is what is the motivation set forth by the examiner to find a reason to combine the references to reach all the claim limitations. And number one, I guess the biggest question is, do they reach all the claim limitations? That's one thing. And then the other thing is about, I think the dissent was really interesting in the case that I looked at, because it went to the crux of it to me, is that was SIBO, the sort of other condition, really instructive for how to treat IBS-D, especially IBS-D, because there was apparently looked like there was some art that said it was, you know, reasonably instructive about IBS, but what about IBS-D? You know, so I think that's an interesting thing to do. So, you know, those may be a couple of things to take away. One is the motivation there in the rejection you're facing, and two, if the examiner gives a motivation, you know, is there a reasonable expectation of success given the nature of the art that you're working in?
No, I agree. I mean, I think in the case you discussed, it was interesting that one of the references explicitly provided a motivation to consider higher dosage. But on the other hand, the 2200 milligram per day was unsuccessful. So that seems to me would have argued against having a reasonable expectation of success if a higher dosage was in fact not successful in treating the condition. But you're right. In the case in the Virtek case, clearly, I mean, there is reasonable expectation of success because it's simply mechanical systems and they are very predictable in the way they perform. But here, of course, there was no motivation to, at least CAFC reached the conclusion that there was no motivation to combine these two references. So you're right. It's sort of the two pillars of motivation and reasonable expectation of success were reversed here. I think the Virtek case to me is quite interesting because a lot of times we see office actions in which the examiner finds, of course, the elements of the claims, but doesn't really explain why you would combine them. And I think cases like Virtek could be very useful in responding to those types of office actions.
Yeah, I can say that I've started studying that case quite a bit.
Yeah.
Yeah, well, that's a great discussion, Reza. And I think any other points, or should we?
No, that's it. And I hope that we can continue this series and hopefully see each other again in a few weeks.
Yeah, sounds great. All right, thanks.
Take care.
All right,
Bye,
bye-bye.
everyone. Bye.